The other, you could try to argue bad faith or malice, or you intentionally violated the policy not to do the high-speed chase. The court in Throneberry rejected that in 2017. We mentioned that in the briefing. Firefighters. Firefighters, they're kind of a hybrid. So firefighters have the same ability to have the same discretion when they're responding to a scene. They have the discretion to speed and to go through red lights and whatnot. Now, one of the interesting aspects of these cases is the fire department. If it's a municipal fire department, and then they will be liable because it's an auto case. So you will have the XYZ fire protection district could be liable, but the individual firefighter won't be. There's in those cases too, Joe, we talk about that, and there's another example in the McCormick case where they talk about official immunity and districts' internal policies requiring firefighters to come to a complete stop, establish eye contact with drivers and vehicles, wait 2 seconds, and then proceed with caution. So in that case, they found the volunteer was still entitled to official immunity where there's no bad faith violation of it. It's certainly my view that this immunity has been eroded, but that's okay. It is what it is. So there's also, now what about a volunteer fire department? So there's a federal statute, 28 U.S.C. 14503, that gives volunteers immunity under specific circumstances. So there may be federal immunity that overlays the state immunity. We've had cases like that. There's an exception to that Volunteer Protection Act that says that the harm cannot be caused by a volunteer operating a motor vehicle for which the state requires an operator to possess a license. So if the fire department person is driving, then they don't get to take advantage of that. Public schools and schools. Any questions on firefighters, EMTs, and those folks? All right, let's move to public schools. So there's a lot of cases on public schools. It's the same general idea. You're going to have the public school. Typically, it won't be an auto case. It'll typically be a premises liability case. So they do waive sovereign immunity for a dangerous condition of property. However, there's a number of cases in the school area where the dangerous condition of property has to be a physical dangerous condition. It can't just be the juxtaposition of pieces of equipment in a gym. It can't just be that a person negligently supervised people on a playground and then they got out of control and that became a dangerous condition. So creative plaintiffs' lawyers have tried to get around that, and try to impose liability on schools, but it's been pretty well rejected. Now there are some cases where they do let that. They do say that they do extend that premises liability in dangerous condition, and we cite them starting on page 14 of the brief of the material. It's the Alexander and the Bover case and the Wynn case. The Wynn case is an interesting case. So the question is for a teacher, is it the principal who's creating the policies and acting with discretion? Then they have immunity. If it's a teacher just executing and following the procedures, then they're not going to have immunity. So there's really a lot of work that goes in before even filing these cases. If you want to, go in and take in an interview, go in and taking witness statements, go in and finding this out. What are the policies in these schools? And the McCoy case on page 15 of our brief, that was our case, and we lost it. It was a girl who was at a gym, was told to do this race with other kids. She injured her knee and had surgery, and the court dismissed the case. They didn't think that the the way the tables were put out on the gym floor was a dangerous condition by definition. And it certainly wasn't a dangerous condition to surmount the sovereign immunity defense that the state was asserting. But that case was both, you'll have, when you have these cases, you'll have both the sovereign immunity of the public school as well as the official immunity of either the gym teacher or his supervisor. So you need to parse those things out. But and for good defense lawyers, they know where those lines are drawn so that they know the type of evidence that they'll need to get to win their summary judgment motions. Now, all the sovereign immunity I've been talking about, it involves tort cases. What about contract cases? Well, the state does not have immunity for a contract case. Zero. They also don't have immunity for an equity case. So it's the Kubley case, it's the DiCarlo case. When the state enters into a validly executed contract, it lays aside all of its privilege. And that was the claim that in a big verdict our firm got last year against the state. They didn't have immunity for that. So the courts distinguish between tort immunity and contract immunity and the level of intent or mens rea that the state does when they enter into those agreements. And the Wyman case, there's a Wyman versus Missouri Department of Mental Health that says the state is not immune for claims for equitable relief. So certainly, if you couch your claim as a contract claim and not as a tort claim, then there is no immunity. You don't even go through that entire analysis. And this is longstanding law in Missouri. So what about state immunity for execution on a judgment? Well, for instance, in this case that we're on appeal on now, it was a breach of contract claim and an equity claim, so there was no immunity. But still, to sue a subdivision of the state, they have to be able to sue and be sued under the Constitution. So we're able to show that under the statute that the Missouri Department of Corrections could sue and be sued for that as well. But then on appeal, the state did not file an appeal bond as required under Rule 8109 for every other entity other than the state. And we did a garnishment, we did some work on that. And there's a separate, what I call a third level of immunity for the state, where there's a provision in the Missouri Constitution that says that the state is not allowed to expend any money unless it's authorized or appropriated by the legislature, which leads to some absurd results where you could have a verdict, a judgment against the state, and they decide they don't want to pay or don't need to pay because the legislature is not going to appropriate it. In fact, there's the case called Ott from 2014 where there was a second injury fund case. They won it after long litigation, and then even after that, the Attorney General refused to pay the SIF judgment, and they went and tried to execute on it and said, no, you're not allowed to execute on that. So you're left with there's the Supreme Court, Missouri Supreme Court in Kubley, which is the case that said there's no immunity for contract actions. They harken back to some old cases when Mary Shelley's Frankenstein was first written. There's a late 1800s Missouri Supreme Court case that says, well, on immunity, we're not going to create that Mary Shelley Frankenstein monster of a state that agrees to a contract, then agrees to have someone do something for it, build a road, build a prison, do whatever, and then then we refuse to pay them, and then they're going to get a judgment against us, and then we're not going to pay them. The state has created no such monster, but it has a little bit. So the state, if you go get a judgment against a state, they don't have to pay you. That's the law. It's the law, too, even if it's a tort action. That's true whether or not it's a tort action or a contract action or whatnot. So, interesting aspect of the law. There is a footnote in that Ott case that says that if the state refuses to pay a judgment, you can apply for a writ of mandamus to the Missouri Supreme Court to order the legislature to appropriate the money. There is no reported cases on that. But one of my arguments was, well, that barrier against executing it against the state shouldn't apply because the state has already appropriated the money for that. They already entered into the contract in the first instance. They already did that, they approved it and whatnot. So, there you go. We talk about these cases in the material. They're pretty old, they're pretty nuanced, and the DiCarlo case, in fact, was specifically that. It was a contractor who did the work, and the state didn't do it. And some of these cases also say that you shouldn't hinge whether or not the state gets immunity on appropriation of money, because the legislatures change. They have appropriation years every year. So with the state of Missouri, as of the end of June, you're in a new budget year, and so no money will be appropriated. So there's another question about how is the state obligated to obey federal anti-discrimination or labor laws. Under the 11th Amendment, there's a tension there. So the way the U.S. Supreme Court has parsed this out is that, for instance, under Title VII, the ADA, and the ADEA, there is U.S. Supreme Court cases that say that, and we talk about them in our brief, that at page 21 and 22. So state employees may not bring federal age discrimination claims against their employers, and also in the Garrett case, the U.S. Supreme Court held that the states also have sovereign immunity from claims under the ADA and under Title VII. Under the FLSA, the Fair Labor Standards Act, what the court said in Alden versus Maine was that there can be no court of competent jurisdiction for a private individual to sue under the FLSA, because the state, that's the context of the 11th Amendment, and whether or not the state consents to suit against it for those claims. So you have a strange situation for federal labor law where an individual cannot sue the state for not paying minimum wage, not paying overtime, or anything like that. However, the Department of Labor can go in and find that the sovereign, the state, violated those rules, but you can't go sue about them. In the case that we had last year, our FLSA count was struck by the court and thrown out. However, we had at least 2 Department of Labor investigations where they came in and found the state of Missouri had violated the FLSA and calculated damages. There was a fight on whether or not we could get that in evidence. We got a little bit of it, but not the conclusions of the investigators. So the Department of Labor has jurisdiction to keep an eye on the state, but not individuals. Ironically, so if the state doesn't have to comply with the FLSA, what about state employment laws? They don't. There's cases that under the Missouri minimum wage law, it does not consider the state or municipalities employers under the definition of employer under those laws. And there's a lot of cases on this in a lot of different jurisdictions. So, and it pretty much goes that way, is that the state or the municipalities are not employers under Missouri minimum wage laws. So I'm sure we all appreciate the irony that the state of Missouri and its municipalities don't have to pay minimum wage, they can employ minors, and they don't have to pay overtime. Now, they in fact do many times. And in the case that we have, they actually contractually agreed to comply with the FLSA wage laws. They had various employment practices that we put together in a breach of contract claim. All right. Any questions before I move on from that? I can tell by the hands that my talk is riveting. What about suing a co-employee and getting around workers' compensation? So that's co-employee immunity. So this area has taken many twists and turns in Missouri law. Let me tell you what the current law is. Well, there was you'll all remember there was a case where the legislature came in and tried to tamper with this. They changed the statute. They basically got rid of co-employee immunity. A bunch of people filed a bunch of cases, and then the legislature in 2012 came in with an amendment to the Workers' Compensation Act, specifically talking about statutory immunity to co-employees. And what this says is that when a co-employee engages in an affirmative negligent act that purposefully and dangerously cause or increase the risk of injury, then you can sue that co-employee. And so this is, of course, a situation where you have a person traumatically injured. Your person's limited through a workers' compensation recovery, but you have a co-employee that drove the car that killed them, or severely injured them, or ran the forklift, or did it. You can think of a million different things how they injured that person. And the question is, can you sue that co-employee? Very limitedly. So. And it's specifically, it's in 287.120. We have the whole statute there on page 24 of our brief. So the Missouri Supreme Court has taken a very narrow view of this. They issued 3 cases last year in 2018, where in each one they ruled that the co-employee did have immunity. We talk about those cases. And basically what the courts do is they focus on foreseeability in these cases. And what they say is that if the co-employee's negligence was the same as the duties that the employer owed the employee, then you can't sue him. The co-employee can only be sued if they do something separate and distinct from his employer's non-delegable duties. The problem is, for a plaintiff's lawyer, is that the employer's duties towards its employees are so broad and over-encompassing, it's very, very difficult to get around. They owe a duty to safe place to work, safe equipment, good training, all that stuff. So in the cases in the Connors, McComb, and Fogarty cases, those are the 3 Missouri Supreme Court cases last year, they all held that an employer's non-delegable duties are limited to injuries that are reasonably foreseeable. In Connor, it was reasonably foreseeable to not well-train an employee how to drive a forklift. In McComb, it was reasonably foreseeable that a supervisor would order a delivery truck driver to go drive in a snowstorm. In Fogarty, it was reasonably foreseeable that a co-employee would fail to provide a safe means for moving stones in construction. So what the courts focus on is whether it was foreseeable to the employer that this could happen. And yes, it's foreseeable to violate your safety rules. If you have safety rules, they know people are going to violate safety rules. So it's a very difficult line to draw, but I'm going to draw it for you right now. If in the end, if you look at the cases, it's only where a co-employee has gone and created a dangerous condition over and above what would normally be encountered. I'm waiting for my chime for my big finish. So there's there's the Burns versus Smith case, which in 2000, the Missouri Supreme Court issued in 2007. Even though there's this statute change in 2012, if you read the cases, they all go back through this long history of co-employee liability law in Missouri, and it all goes to that foreseeability. So what the supervisor in Burns made his employee do is he made him weld next to a pressured water tank and instructed the employee to run till it blows. And what they specifically said in that case, if the supervisor had just had him welding next to this tank when it blew up, that would have been okay. But if he ordered him to run till it blows, that created the hazardous condition. There's other cases where a supervisor the elevator broke, so he had people using an elevator, was using a forklift and pallets, and there they specifically created the dangerous condition. The only case that has ruled on this since the 2012 statutory amendments is Brock versus Dunn. Brock was issued by the Eastern District, and it's currently pending before the Supreme Court granted transfer. It was argued about a month ago, and so we're waiting on a decision. In that case, what the supervisor did is they had a grinding machine. Was it a grinding machine or a cutting machine? That had guards, and what the supervisor did there is he specifically had the employee take away the guard and use it without the guard, even though there was signs not to use it without the guard, and the employee lost a limb. And that case was tried in St. Louis County. And in that case, the court said that they found it hard to believe of any more clear action on behalf of a supervisor to disregard all of the safety rules of the employer, order the employee to do the work contrary to the employer's safety rules, contrary to the machine guards, and go get injured. That was not foreseeable to them. And we are hard pressed to find that employers' non-delegable duties extend to the possibility that a supervisory employee, against both logic and an employer's instructions and machine warnings, would dangerously modify a machine. Now, that though, and the Missouri Supreme Court has granted transfer to that. All of the other three cases last year went to impose immunity and block those types of cases. And there are other cases that say, and specifically the Peters case, the Peters case from 2016, we talk about all these cases where there's other cases where the Supreme Court has said, well, you know that supervisors are going to disobey rules and have people do stuff contrary to these rules, so that is foreseeable to the employer. There was, in the Peters case, they said the way you were stacking these dowel baskets and doing these things was foreseeable, so we're not going to give you an exception to the co-employee immunity rule. The bottom line on these cases is that the plaintiff has to show two things, and you set this up ahead of time, and you try to plead it, and you try to prove it in your depositions, is the defendant, you need to show that the defendant co-employee owes a personal duty beyond the employer's non-delegable duty to provide a safe workplace, something else. And you need to show that the defendant's conduct, the co-employee, created a dangerous job hazard beyond the foreseeable risks that the plaintiff was already assigned to. It's unusual facts. And in doing that, the employee you're pointing to did an affirmative negligent act. It isn't just this something more that people would talk about before. It's an affirmative negligent act, not a mere omission. It's commission, not omission, that puts the plaintiff in danger and injures them. It's a very narrow limit because the legislature and the courts want to provide workers' compensation immunity and extend it as far as they can. So the circumstances under which this is permissible is very limited. But it's so limited that it almost swallows the rule, which is what the court in Brock was pointing to. So that's the end of my prepared remarks on immunity. At at 2:51. What questions do I have? Seeing none, that's what I say when we pick juries, seeing no hands. We're going to take a short break, and then we're going to dive into ethics with Debbie and I. Thank you.